I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are bringing you compilation number 113, and we are going to be doing, only for the second time, focusing on the sovereign citizen when it comes to this compilation. And that sovereign citizen today is going to be Mr. Albert Hicks. If you have never seen an appearance by Mr. Albert Hicks, today you are in for something, because his appearances, they tend to be pretty wild, pretty confrontational, but we have him in 3 different judges' courtrooms for this compilation. Before I give you the name of those judges, no, there will be no commentary at the end of this, and there will be chapters added for your convenience, just in case you want to jump around. And with that being said, guys, let's give you the rundown on these judges. First, we will be in the courtroom of Judge Donna Milhouse, and know that all of these judges are out of the state of Michigan. Obviously, Albert Hicks resides in Michigan, so all of these will be out of the state of Michigan. So first, we will be in the courtroom of Judge Donna Milhouse, and rest in peace to Miss Milhouse. She passed away earlier this year. We talked about it here on the channel a couple months ago. Second, he will be in the courtroom of Judge Shawn Perkins. And last but not least, he will be in the courtroom of Judge Kenneth King. Listen, I want you guys to give me your thoughts down in the comments on Mr. Hicks. Like I said, this is a lot of, oh man, I don't even want to mess it up for you guys. Some of you guys already know, but for you guys that are first now just jumping on here and seeing this, it's gonna be crazy. But with that being said, guys, let's just go ahead and jump into number 113.
People versus Albert Himmer Hicks. Names for the record. Attorney first.
Okay, please court Harry Boffin on behalf of the defendant. Sir, would you state your name for the record?
Albert Hicks Jr.
Thank you. Good morning.
The defendant
Good morning, Your Honor.
That he does not wish to be represented by counsel this morning. I will remain in a potential advisory capacity just in case.
Okay. Is that correct, Mr. Hicks?
Yes, that's correct.
Okay. You know that, so let me see what's happening here. I see an offer that ends up dismissing a lot of matters. I can't be your lawyer, so I'll just tell you what's here. And Corporal Spidell is here. See what I'm just trying to make sure I understand the offer. So you have 8 open matters, and there is a recommendation to dismiss 6 of those matters in return for a plea on 2 of the matters, and both matters are being reduced to driving with improper plates. I think, it was driving unregistered motor vehicle reduced to driving with improper plates. Oh, I'm sorry. And the other one is being reduced to, I don't get this other one, Ms. Jansen. Is it being reduced to failure to report accident under MCL 257.621?
Yes, that's correct. That's a 0-point offense that doesn't abstract, and
okay,
it's a maximum of $100 for a fine.
Oh, okay. So the false insurance information ticket would be reduced to failure to report accident, which has a $100 fine cap and is does not abstract for, according to the prosecutor, for insurance purposes. And then the other one would be to reduce the driving an unregistered motor vehicle to improper plates. And then the other 6 matters would be dismissed. Mr. Hicks, would you like to avail yourself of that offer? That takes something that was a $500 fine as the maximum to a $100 fine as a maximum with no points.
I never had a license. I never acquired a license. I have no contract with any company.
This has nothing to do with a license. So those license matters. The offer is to dismiss those.
You don't have to. I'll defend myself against them.
Okay. you want to go through all of these tickets then?
Let's run.
Okay, so let me just say, Mr. Hicks, if you're making a motion for, I'm not sure what you're doing. You
I'm
sure you
making
don't
a
want to have, let me just
mistrial.
ask.
I'm making a motion for a mistrial for the simple fact the officer did not have cause of action on private property. As far as the license is concerned, I'm going to rely on the decision from the Supreme Court and constitutional defenses.
Well, can you tell what those are so that the prosecutor can
Of course.
say what she's
I
saying?
travel with the common law. I have the right to travel. Shapiro versus Thompson states that. Murdoch versus Pennsylvania states no state shall convert a secured liberty into a privilege. Y'all are calling driving a privilege or traveling a privilege. It is not a privilege. It is a liberty. Shuttlesworth versus Birmingham says I can ignore the license and engage with the right with impunity. So you can't punish me for any of this.
Thank you.
I'm going total constitution on everything. This is a court of law and not equity. So all those civil infractions, y'all can wrap that up because nothing was injured. No one was injured and nothing was tore up.
Just so you know, Mr. Hicks, there are no civil infractions up today.
Those have to be civil infractions if you're trying to charge me money.
I'm just saying, you mentioned civil infractions, and I just want to make sure that you understand that these are all misdemeanor offenses against you. I'll go through them. Let me tell you what's up.
I already have them right here in front of me.
Well, I'm trying to do my due diligence, Mr. Hicks. Driving while license suspended, driving an unregistered motor vehicle, driving without insurance. Those are the 3 counts. Also pending is the driving while license expired. Count 1 is failure to display a valid operator's license, not on purpose, person. Count 2, driving unregistered or untitled motor vehicle. Count 3, driving with improper plates. And then the last one I have, the charge is providing false or fraudulent insurance information.
That will have to be proven.
Okay. Those are what they're scheduled for a bench trial before the court right now. And what I was trying to explain to you is that there's an offer that's been made by the prosecutor.
I understand.
Hold on 1 second. I'm already dismissing 4 of the matters because the officer has not appeared. Okay. So the prosecution couldn't go forward. So those are being dismissed without prejudice. And those would be counts 1, 2, and 3 of SP 1335615. I assume Officer Reed is not present. And that was scheduled for trial. I'm dismissing those, okay? The driver's license expired, case number SP 1218560. I'm dismissing that count 1 that's up as the officer Hernandez has not appeared, okay?
I wonder why.
Don't worry, a lot of people, that happens sometimes. Well, let me just say, let me just say, they may have been here before. I don't know, because some of these you haven't appeared for. So I don't know if the offer would change. So the only matters that are pending now, the other matters are gone, that were scheduled for today, would be the fraudulent false insurance information, SP 1055542, and SP 1055540, failure to display an operator's license, driving an unregistered motor vehicle, and driving with improper plates. Those 3. Right now, and I don't know if the offer would change because some of the matters are gone. But right now, with those matters here, the only plea offer that's being made would be to failure to report an accident, which has maximum sentence of a $100 fine.
What accident are they speaking of?
No. So just so that you know, Mr. Hicks, what the prosecutor does a lot of times is that in an attempt to resolve a matter, they'll have you plead, but they'll ask the court to accept the plea to a lesser offense that doesn't.
I understand that doesn't hold as much weight as
Yeah, that doesn't affect you as
I
bad.
understand it, but by the way that I live now as a researcher, I really don't need it. I do everything constitutionally. I don't follow laws or codes. I follow
Okay, well then that's what this is about. These are laws or codes.
Those are not laws, those are codes.
Okay, so if you
they are not laws.
Well,
the Constitution, there holds no weight with the Constitution nor the Supreme Court. And I'm
okay,
willing to take it all the way to
Your
the Supreme
Honor,
Mr. Hicks, just hold on, please. I'm just trying to get.
Because it seems like you're trying to talk me into something.
I'm not trying to. Absolutely not. That is not my role, Mr. Hicks.
From the
Mr.
Department of Transportation.
Mr.
I
Hicks.
have nothing to do with them. Never had a contract with them.
Okay, Mr. Hicks. I'm not trying to talk you into anything. I just want you not to come back and say that I didn't explain something to you. And I am not your lawyer. I'm the judge. So I just want to make sure, though, that you don't come back with something else. And I just wanted to let you know, because you didn't talk to the attorney, what was being offered. That's all. And you made your argument. I'm going to have the prosecutor make an argument, but I've already gotten rid of some of these, okay, for other reasons. And so I just want you to know that at least with respect to the offer that was made before, and it may have changed, these other three matters would be dismissed, I think. Yes, these other three matters would be dismissed. The failure to display, the driving and unregistered, and driving with improper plate. But that's only if you plead.
I will not plead. I refuse.
Okay, all right. No problem then, Mr. Hicks. I'm just telling you what that offer is from the prosecutor.
I understand.
It has nothing. So
I understand. I'm 57 years old. I speak English well, and I translate it real well.
okay,
I even have you on caption. I'm reading everything that you're saying.
okay, all right. That's good. I just want to make sure there's no issue. Attorney Jansen, what about so we have 4 matters that are pending. Corporal Spidell is here, and he's here on those 4 matters.
yes.
Okay,
Your Honor, go ahead.
go ahead. So Mr. Hicks has made a motion before we move forward with the trial.
Your Honor, I guess I would like to speak with Corporal Spidell about these cases. But prior to that, I just wanted to clarify that the defendant has submitted to jurisdiction.
Thank you.
Thank you. I have had the chance to speak with Corporal Spidell, who was the ticketing officer on this case.
Okay.
We are requesting an in-person trial date.
Beautiful.
So just for the record, all we have left are the 4 misdemeanors that I indicated.
Yes, Your Honor.
Okay, all right. But I need you to be ready to respond to Mr. Hicks's motion. He just made an oral motion. I don't know if you want to do that now or do that at the time.
I can do that at the time. If you could actually reiterate his motion in writing, that would be
Can you
helpful.
put that motion in writing, Mr. Hicks? And you would have to give it to the prosecutor, Attorney Jansen.
Well, the thing is, when I was reciting it, no one was taking record of it.
We have record. We have a record of it, Mr. Hicks.
So
I mean, we have a record of everything. No. Let me tell you, Mr. Hicks, a lot of times written motions are required. And usually, if that happens, then written responses are required.
Okay, beautiful.
I'm just trying to.
Where would I bring or send these motions?
You can you can file it with the court and with a copy to Attorney Jansen.
You will have to send me that information because I have nothing to jot with at this moment.
she'll chat it to you. But the filing with the court is different. You should already know how to, there's nothing special about that. Okay. And give me 1 second. I'm gonna try to get a date. So that means you would come down to court.
Well, I wanted to do it in the first place.
Okay.
For,
all right. It's still scheduled for a bench trial.
Beautiful. For a bench trial.
So I can schedule this for the adjourn this bench trial until March 27.
Hold on.
In person, 9 a.m. It is right now it's scheduled for a bench trial. And so that's what we would have been going forward, but we'll move it then in person. So make sure that you come in if you have any witnesses or other evidence, make sure they're present. And if there's any motion to be heard prior to the bench trial, we'll do that.
I said everything I had to.
Do you have that, Ms. Jansen?
I asked for a bench trial.
Yes, I've emailed Corporal Spidell with that date. March 27 at 9 a.m. Thank you so much.
Our schedule. Hopefully we can get started close to that time. Yes. Mr. Hicks.
Are they going to have me just sitting around like I'm doing today? Because I do have a business that I run, and I will be asking for costs and fees.
Well, you wouldn't be able to get costs and fees for sitting around because that's not anything that's allowable.
Oh, it's not?
No, it's not. It's not allowable. It's not allowable because the court has to do its business for everybody. Okay.
Even when I win this, I'm not allowed my costs and fees.
We're not going to talk about that. You were talking about sitting around and waiting. So you're not.
I mean,
you're not.
Like a game to try to pressure me out. But
Mr. Hicks. So Mr. Hicks, just like I'm not imposing any costs and fees on you when you missed your court dates. You missed court dates earlier. And there's, I mean, you've been doing that. I see it.
I walked in the same day down at 36th District and rescheduled.
So Mr. Hicks, I already made my decision now. Come on. I made my decision. You asked me and I said I wouldn't be able to do
try the intimidation thing.
I don't ever intimidate. You know what? You can only let me just, Mr. Hicks. I'm gonna talk to you, Mr. Hicks. Can you listen to me for a second? You can only be intimidated. No, you can only be intimidated if you feel insecure. So if you feel insecure, that's where that comes from.
Not feeling
insecure. So nobody's trying to do that, Mr. Hicks. I just say?
We'll see.
But Mr. Hicks, can I just say that you've been given I don't even want to say because we've been following the law, you've had cases dismissed because that's what we're doing. Because of it. Not in spite of it. Okay. So I hope it's fine that that's happened. So we're down to 4 matters and it sounds like you have no problem with coming in. Correct?
I still would like a jury trial. I would love a jury trial.
You're wanting a jury trial?
Yes, that's what I asked for in the first place.
You asked for a jury trial at some point and didn't appear. And so it went into show cause status.
That was done on purpose. That was done by design.
You did?
Thing inside of what's that little township? Every time I ask for a jury trial, no one wants me to come in and speak my law, speak the Constitution in front of people.
Wait a minute. So you didn't, I'm just saying, you didn't appear several times. I'm looking here. So let me just say, if you want a jury trial, I have to give you another date. I didn't know that. So because the last time you were
filed, I have a paper here that says I would like a jury trial.
Okay, Mr. Hicks, I scheduled a jury trial for you. It looks like a couple of times. and you did not appear. So,
Yes,
but
I did.
okay,
Oh.
but let me just say, we were ready. Okay, Mr. Hicks, you want to get some counsel for that? Because it really takes a lot. I can't be your lawyer. We have to choose a jury. There's a lot of things that happen. And if you don't believe in the law to begin with, let me do this. Let me
I
do
don't
this.
color of law. I believe in the Constitution, the supreme law.
Mr. Hicks, you can put your motion in writing. Ms. Jansen, you respond to it, and we'll schedule that for a hearing date. Then you don't have to come in. And then we'll see if this moves forward. If this is moving forward for a jury trial, I have to give you a jury trial date. That's completely different from a bench trial date. Okay? Like our scheduling is different.
I'm getting the fees out of this.
Well, I'm just saying. I don't know who can award them to you.
The court can. That's totally
Miss, hold on. Well, why don't we do that? We'll use the March 27th date as the hearing date on Mr. Hicks's motion. That I think your motion is, so you were saying something about not being subject to
no cause of action on private property.
Okay, so why don't you put that in writing?
And I will.
Put that in writing, and Ms. Jansen will, so that needs to be filed by, I'll just indicate.
And just for the record, is suspicion a misdemeanor or a felony?
Oh, you don't have any felonies.
No, I said is suspicion a misdemeanor or a felony?
You don't have any, these are not felony cases.
Thank
These are all misdemeanor cases.
Beautiful. So he had no cause of action on private property.
Well, I don't see that as, if you want to just do an oral motion right now, Ms. Jansen, you can. I don't know if you're prepared for it because he's saying that now.
I said it at the beginning.
Okay. No, I mean, at the beginning of today.
I'm so sorry, Your Honor. I don't know what he means by what he's describing. This is a ticket that, if we want to go into the facts, then
No, you don't have to.
Yeah, go into the facts. Come
No,
on.
no, because I might have to hear. No, we can't do
Coming
that.
in with the Constitution.
Not
I'm
with
waiting
me.
on him. Make sure he's there.
Mr. Hicks,
I see him in the neighborhood anyway.
Your Honor,
Mr. Hicks, Mr.
Okay.
Hicks, Mr. Hicks.
I have nothing else to say. Y'all
Mr.
using color
I'm going to
law.
request a bailiff. Your
Yeah,
Honor.
request one, please.
Mr. Hicks.
Is she scared? Tell her to call the police.
You don't need one now. He's at home.
They do not want to go by the Constitution.
Mr.
It's a good
Hicks,
thing I'm filming this too.
Mr. Hicks, you're not supposed to film it.
Oh, yes, I can.
No,
I can do anything I want to in my house. You have no thing underneath my private property. You have no
Okay.
control.
all right. We'll see you. All right. I don't know what to tell you. We'll see you on March 27th. You can file the motion.
I will.
Make sure the motion is filed by,
I got 14 days or so.
I'm just gonna give you a little bit more.
Judge Milhouse, I have no problem with you.
I mean, no, but Mr. Hicks, I don't need you to become angry.
But
That's the thing. That's the thing.
No, that nobody wants to follow the
No.
law.
But Mr. Hicks, people can disagree about what the law
No,
is.
it's not about disagreement. It's right or wrong.
Well,
It's
Mr.
right
Hicks,
and then there's wrong.
Mr. Hicks,
It's not about disagreement.
Mr. Hicks,
The Constitution was written so it wouldn't be no disagreements.
Mr. Hicks. Oh, there's always argument about the Constitution, always. Just so that you know, just so that you know, just so that you know, yeah, you wouldn't need me if there wasn't. So, I just want you to understand that, and what we have to be here is civil, okay? We really have to be civil with, we really need to be civil with each other, and I appreciate.
Not using the same tactic.
Yeah, but there's no tactics here.
Yeah, it is.
So, well, I'm not trying to do a tactic. So let me just give you a date, and you can send it, and be careful.
I'll bring it personally.
I just so for the record, because I have to say it for the record, I have scheduled some jury trial dates for you in the past, and maybe, I don't know if it's on any of the matters, probably on some of the matters that I'm
It's
just.
not in my paperwork.
Just today. Just for today. I'm saying.
But it's not inside of none of my paperwork.
Okay. Well, I've said it on the record. So
Okay.
those count. And I listened very carefully. And the last time I scheduled these matters for bench trial, it helped you because there's some officers that did not appear today. And so those matters are dismissed.
Matter of fact, do me a favor.
I can't do you a favor.
Please call the other cops in.
No,
Bring
I'm
them
not.
I'll take on all of them.
No.
Sworn in on the Constitution and don't know it. I'll take them all on. Let's get it.
Okay.
You. Do you want me to start talking to people in the breakout rooms? I don't see anyone in the room.
We're gonna keep calling. You can talk to Mr. Hicks right after I call this case.
Oh, very good, Your Honor.
All right, Mr. Hicks, are you there? I need a city attorney.
Yes, I'm here.
All right, this is the city of Detroit versus Albert Hicks Jr. Case numbers SP 1442547, counts 1, 2, and 3. SP 1442765 And it looks like the rest of this stuff, then I have SP 1500871, and it looks like the rest of this stuff he's already entered a plea into all this stuff.
No, sir. No plea.
Well, that's not what it says here, sir.
I represent myself. I couldn't enter the plea. I never plea. You can check my record. I never plea.
Oh, maybe I found you guilty then. Yeah.
No, I haven't been. Matter of fact, I came inside there personally a week or so ago. And the young lady, the security officer, came out and said that I'm supposed to report today.
No, this is on some old stuff. All right.
I never entered the plea.
So do you not want the representation of counsel?
No, thank you.
Okay. There you go, Mr. Take, that's your first break of the day, Mr. Soroki, you know what I mean?
Judge, I know how to deal with everybody. So I said, I know how to deal with everybody, any type of client.
Yeah, I know, but he doesn't want it.
Right,
So
I understand.
We can't force it on him.
Yeah.
No, I understand.
Yeah. So you can
Take it as a plus.
So Mr. Lee, today is the date and time set for a show cause. As for purposes of arraignment, sir. We'll do it like this. I'll enter a not
Are you
guilty.
talking to Mr. Hicks or Mr. Lee?
Pardon me?
Yes, you should be able to follow the works on
Are you talking to Mr. Hicks or Mr. Lee?
Mr. Hicks, I'm sorry.
You should be down with area code 929.
Mr. Hicks, for purposes of arraignment, I'm gonna enter a not guilty plea on your behalf and give you a $0 bond, all right?
I object, Your Honor. That would be practiced in front of the bench.
Say that again.
I object that would be practicing from the bench, practicing law from the bench. You will have to recluse yourself if you hold on to that.
All right. Well, I deny your motion. So go ahead. How do you want to proceed?
I would like for everything to be dismissed, if it pleases the court.
Deny. What basis?
You haven't even let me tell my grounds.
All right, basis. Give it to me.
For one, a ticket is a bill of attainder. Article 1, Section 9, Clause 3 of the Constitution of the United States, no bill of attainder or ex post facto law shall be passed. You can have a written assistance
All right, let me
to equity that transmitted into law penalties.
Let me stop you right there. We have, first of all, we have a problem with the transmission. You're breaking up really bad, and we can't get that on the, turn your video
I
off.
understand.
Maybe turn your video off, that will help. Let's see. All right, try it now. Let's see. Go ahead.
Did you hear what I said?
Yeah, I'm listening.
Okay. Article 1, Section 9, Clause 3 of the Constitution of the United States. No bill of attainder or ex post facto law shall be passed. You cannot have a writ of assistance that has civil equity that transmits into law. Number 2, there is no sworn statement from an injured party. Number 3, the officer did not even sign the ticket. That's under law of penalty of perjury. I'm asking that all of these be dismissed.
All right, I'm going to deny that motion. All right, how else do you want to proceed?
That's your declaratory judgment?
I'm going to deny the motion. I denied the motion.
Okay, let's go to court.
Trial?
It don't matter, because y'all, I don't understand how y'all run y'all system. Y'all practice against the law. I'm a common law.
Well, read the court rules, and you'll learn a little something.
The court rules go against the law. Y'all practice against the law, against the Constitution. I'm all common law.
All right. Well, we're beyond that.
Okay.
All right.
So you say. So are you going to prosecute this, or somebody else going to prosecute it?
Stop. Let's not keep going. All right. You want a trial date, or not?
It's up to y'all. Remember, y'all make all the rules.
Trial date. You want to, let's give him a jury trial date.
Jury trial?
Yeah.
How long do I have to turn in my briefs?
I'll give you some dates in a second.
Okay.
Here's a. All right.
Scamming. With a smile on your face. If it pleases the court, what jurisdiction are you charging me on?
I asked the question, sir.
I just said if it pleases the court.
I know, and I'm telling you, I asked the questions. I appreciate your
We can do it.
your respect for the court, but I asked the questions. I told you to read the court rules.
We can do it March the 5th. Let me check and see.
The court rules.
Is it
What
March the 5th?
jurisdiction are you trying to charge me on?
Is March the 5th a good date for you, sir?
No.
Okay, that's my good question. We can do March the 19th. Let's see how that looks for you, Judge.
Give him a little further out,
Further
so
out,
he can get his some stuff together.
we can do May. You want to go all the way to May?
Yeah,
Let's see, May 6th. No, let's do, one second, farther out, because I don't want it to collide with all your trials. I think we should do group 2. We can do June the 11th.
June the 11th is gonna be the jury trial date.
June the 11th?
June the 11th. So, let's put, your final pretrial date will be let's see, put that a day before. That way, that'll be the date we'll argue motions on June the 10th. And I will want the motion filed, your motion filed by motions due by May the 24th will be your motion, and now these
May 24th.
May the 24th, and the city will have 7 days to respond. So the response to the motion will be due by May the 31st. All right, so we have your motion's due by May the 24th. You make sure you serve the other side, and they'll have until May the 31st to respond. We'll listen, and I'll review the motions, listen to arguments on final pretrial of 6/10/2024 with a jury trial set for 6/11/2024 at 9 a.m. All right.
I appreciate you, Your Honor.
All right. Have a very good day, sir. Best of luck to you.
I just did. Thank you.
Thank you. All right. Let's go with Albert Hicks. Albert Hicks. How he got on my docket, I don't know. It's just the city of Detroit versus Albert Hicks Jr. Case number SP 1442547, counts 1, 2, and 3. SP 144-27651. Appearance for the record, please. And strike that. Wait a minute. SP 150-08721. Appearance for the record, please.
That one ours?
Yeah.
Elwood S. Berry Jr. On behalf of the defendant, state your full name, Mr.
Albert Heimer Hicks, and no one is to speak on my behalf.
Okay.
I'm my own attorney.
You're your own attorney. You're an attorney registered by the state of Michigan.
Licensed to practice law, and you've been practicing law over the bench.
You say I have been?
Would you like to litigate against me?
I'm not litigating anything against you.
Okay, you have been practicing law across the bench since we started this. And I'm
Okay.
challenging jurisdiction today.
Okay. What do you want to do, Mr. Hicks?
I'm
You want a
challenging-
trial? You want a trial date or you want the
I'm
offer that's in
challenging
the file?
jurisdiction. I'm challenging jurisdiction.
Okay, put it in a motion.
I don't have
Write
to
it
put
up.
it in the motion. I don't have to put it in the motion.
If I say you do, you do.
No, you don't have the right to do that. You don't have a Congress number. You don't have
Okay.
delegated authority to do that.
Okay. All right, well,
I'm
Trial
challenging
date?
jurisdiction.
trial date, I'm denying, what is your motion? You're challenging my jurisdiction?
I'm challenging everybody's jurisdiction because you have none.
Okay, so,
Honor your oath of office, please. Honor your oath of office, okay?
are we going to sit here and debate those
It's not a
positions?
debate. It's my constitutional right. It's my constitutional right.
You think so?
I
Okay,
know
so,
so. Are you violating my constitutional rights on how you deem them to be?
no, I'm not.
Okay.
I don't believe so.
And then please don't have me file for Title 18, 242.
Please do.
Okay, I have a
Please.
transcript from all the other times I talked with you because you've been practicing across the bench for the longest.
Okay, so what are you gonna do today, Mr. Hicks?
Challenge jurisdiction
And how are you challenging that?
because you have no jurisdiction. You have the burden of proof is on whoever assessed the jurisdiction. Who's the assessor of jurisdiction?
I am, in this case,
Okay.
and I deny that motion.
Why you
If that
denying the
even-
motion? Because you don't
Even-
have.
even-
You don't
Even
have.
if that is, so Mr. Hicks, you're a grown man. Let's have a few seconds, wait a minute. Let's have a few second conversation, okay? Now,
Okay.
let's get this straight. I'm running this show, okay? So if I'm gonna allow you to talk and say what you have to say, you're talking about challenging jurisdiction right now. That's what the discussion is. I say I have jurisdiction. The court rules say I have jurisdiction. The Constitution of the state of Michigan say I have jurisdiction. So I'm denying, no, don't talk while I'm talking. I'm denying your motion as far as you contesting my jurisdiction. Okay, so take your hood off, please. So other than that, what else do you want? How do you want to proceed now moving forward?
I motion to dismiss.
I'm denying that motion. Okay, let me ask you this. What
Beautiful.
basis are you denying the motion to dismiss?
Because no crime, a bill of attainder, no injured party. I told you all of this at the beginning, and you denied everything. You practice over the bench.
Okay, so now I'm going to give you two
As
options.
a matter of fact, hold on, give me a minute. You
Go
even
ahead.
went through a 10 and 3 because you started threatening me. You remember that?
No, you were the one, wait a minute, you were the one, Mr. Hicks, that said, oh, you can say all that while you're on the bench. Did you say that last time?
Do you have the transcripts? Yeah, I said it. Yes, I did.
Yeah.
Yes,
yeah,
I did.
I thought about that.
You don't even have a
I
license
thought
to
about that.
practice law.
Listen, this
You
whole,
have a license to practice law. Come on, the jig is up. The jig is up.
all right, so now the jig is up with you. So I'm not letting you say any more about this. I'm denying your motions. Now, I'm gonna give you two options. The first option is you can either take the deal that's in the file, or we can, okay, don't talk while I'm talking.
I tell you what.
Don't talk while I'm talking.
A few minutes. I got
Don't
your
talk
paperwork ready. I got your paperwork ready. You really
Don't
want to
talk.
You
There
really
you
want
go
to do
again.
this?
All right. Now I'm going to give you one more time to interrupt me. If you interrupt me again, I'm going to hold you in contempt of court. Okay. All right. So the other option is we set a jury trial, and we'll set the jury trial. I'll give you motion dates where you can have the dates and you can put all of your stuff in writing that you want before the court. And I'll make a date on that date. I'll make a date when I'll rule on those motions. So do you want the offer or do you want the jury trial date and the motions dates?
I thought that the trial was up to me, whether I have a bench trial or a jury trial. It's not up to you.
No, it's not up to you. I'm giving you, everybody has a right to a jury trial.
Absolutely.
And I'm going to allow you to exercise that jury trial right. I'm not going to sit here and entertain a bench trial for you. Let a jury of your peers determine your innocence or guilt.
Why would I do that?
How?
I have the right to either or. You're not the one.
No, you don't have a right to. No, you don't have a right to either or.
Yes, I do. Of course, I do.
All right. All right. I'm moving on.
All right, move on.
You didn't answer my question, so I'm moving on. And I'm going to put you out, or at least mute yourself. Very well. Officers, be safe out there. Have a very good day. All right, let's do this and let's go back on the record one more time with Mr. Hicks.
Record, Your Honor. Chiku Mason, City of Detroit, 434.
Yeah, something's wrong with your volume, Ms. Mason.
Oh, I'm sorry, Your Honor. It might be my mic is down. For the record, Your Honor, Chiku Mason, City of Detroit, 43471. This is the date and time set for a final pretrial in this matter. Your Honor, I did subpoena my officers to be here today for the final pretrial, and I do not see them here today.
Remove your hat, please. No drinking, please. Treat this like you're in the courthouse. Remove your hat, please, Mr. Hicks. All right. What are we going to do? The officers were supposed to be here today. I'm only dealing with SP 1442547 counts 1, 2, and 3, SP 1442761, and SP 5008721. I'm only dealing with those matters, and the officers are not here, so we're going to make this easy. And now, what I don't appreciate is, I thought about that comment that you made that last time. Basically, you're almost like a little lightweight threat that you had toward me, saying that, oh, I'm only doing this, I'm only this way because I'm being protected by the bench. That's absolutely not. I'm the same way 24 hours a day. Okay? So let's get that straight. This robe has nothing to do with me as a man. But all right, I'm going to dismiss the cases because no officer appeared.
I would like to collect my costs and fees.
Pardon me?
I would like to collect my costs and fees for having to defend myself.
I don't want to hear anything else you have to say.
Oh, beautiful.
All right, bye.
Ready, drive.
Okay. We can call it.
Calling case 230-601-1701, the people of the state of Michigan versus Albert Hicks. The defendant is charged with count 1, assault with intent to great bodily harm, less than murder or by strangulation. Count 2, domestic violence, aggravated second offense notice. Today's the date and time for an examination. Appearances, please.
Good morning, Your Honor. Madison Oro on behalf of the people requesting permission under MCR 8.120P under the supervision of Attorney Shelley Gray.
Attorney Monica Sanford, P6. Attorney Monica Sanford, P62315 on behalf of Albert Hicks.
Today's the date and time set for preliminary examination. Are we ready to proceed?
Your Honor, the people are ready to proceed.
How many witnesses for the people?
One witness, Your Honor.
And Mr. Hicks, tell us your name for the record, sir.
Say your name.
Albert Hicks Jr.
All right, call your witness.
The people call Ms. Kimberly Hubbard to the stand.
Give your name and spelling to the court reporter. Okay, stand closer to the podium so I can see you and raise your right hand. Back towards the podium where the prosecutor is. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please have a seat in the witness box next to the bench. Keep your voice up nice and loud and speak into that microphone that'll be to your left. You may begin when you're ready.
Thank you, Your Honor. Can you please state your name for the record? Kimberly Hubbard. Thank you. Ms. Hubbard, I want to draw your attention to November 22nd, 2023. Where were you on that day?
At my house, 18212 Stratmore Street.
Okay.
Detroit.
So you just said that's in Detroit. That's in the county of Wayne?
Yes.
Thank you. And did something happen on that date that brings you into court today?
Yes.
What happened on that day?
I was assaulted by Mr. Hicks.
Okay. So you stated you were assaulted by Mr. Hicks. Is that Albert Hicks?
Yes.
Okay. And how do you know that person?
He was my partner, and he is the father of my children.
Okay. How long were you guys partners for?
Around 14 years.
And do you see that individual in the courtroom today?
Yes, I do.
Can you please point to him and identify a piece of clothing that he's wearing?
Yes, he has on a black vest.
Thank you, Your Honor. Please let the record reflect that the defendant has been identified.
Noted.
So going back to this assault, as you stated, can you just explain to the court in a little bit more detail what occurred?
Well, I worked a 12-hour shift that day. I worked for a before and after school program. So I worked from 6:30 a.m. to 6:30 p.m. I get off of work. I get in the car with Mr. Hicks. He drives me to and from work. I get into the car. I can tell that he's a little upset. So we're talking, and he begins to argue about some things from the past, jobs that he was owed for in the past. So that's how the argument started. I didn't really feed into the argument. I wasn't trying to respond to the argument. It was just kind of, let's just get home.
Okay.
So we end up pulling into.
I'm gonna stop you right there. I'm sorry. I just want to ask you a few questions about what you just stated. Okay, so just to clarify, Mr. Hicks picks you up, takes you and picks you up from work.
Correct.
Okay, and on this date, November 22nd, he was picking you up from work?
Correct.
Perfect, and you got into the vehicle with him, and you stated there was an argument, right?
Yes.
Okay, and so you were going into a little bit detail, sorry, about what the argument was pertaining to, and so can you state that again?
It was about a prior job that he had done. He just homework. It was a prior job that he had done that he wasn't properly compensated for.
Okay.
That he says he wasn't properly compensated for, which I have nothing to do with.
Yeah. Okay, so after he is, expressing these things to you about these different jobs that he hasn't been properly compensated for, what happened next?
He just kept yelling, "Oh, I'm gonna get my money." The job he is referring to, he had done for my current employer. So he felt like I had something to do with that, but I had absolutely nothing to do with that. So I just wouldn't feed into it because that has nothing to do with it.
I understand. So, earlier in your testimony, you stated that Mr. Hicks assaulted you. So at what point did this argument between the two of you turn physical?
Once we got to the residence, which is the Shuttlesworth residence, which I spoke of, we pulled up into the driveway. He got out of the car and he went into the home. I did not go into the house because I did not feel like he was calm enough for us to have a conversation or for us to be in the same house.
Okay, so sorry, I'm so sorry. Just to clarify, so you guys are currently on the drive home while this verbal argument.
With the verbal.
Perfect. And so you get to the home, and Mr. Hicks parks the vehicle, goes inside, and you stay in the car.
Yes.
Okay, great. And I'm sorry, can you continue back?
I stay in the vehicle. I'm watching movies on my phone. My daughter's sitting in the car with me. She's going back and forth into the house. I asked her to bring me my throw blanket out to the car. I was going to stay in the car. Mr. Hicks continued to come in and out of the house to pursue the argument, but I did not feed into that argument. When he realized I wasn't going to feed into the argument, the last time he walked out, he asked for my keys, and I told him he was not getting my keys.
Just to clarify, Ms. Hubbard, the vehicle that you guys, the keys that you're referring to, they belong to the vehicle that you
No.
wanted? Oh, okay, just wanted to clarify.
House keys.
Okay.
House keys. He wanted my house keys, and I told him no. And that's when he pursued to bang on the window. And I would not open my door. I kept my door locked, but he had set keys to the vehicle. So he unlocked the vehicle and pursued to get in the back seats of that vehicle. And first they started off as verbal, and then when he wasn't getting the responses that he wanted, they turned into a physical attack.
Okay. Ms. Hubbard, when you say physical, was there, when you say physical, can you just explain to the court, what it is that you mean exactly?
He tried to put pressure on my neck with his wrist. So when he did that, I struggled to breathe. And at some point, I'm not sure when, I was hit in my left eye, and had to receive liquid stitches in my left eye. I'm not sure when that occurred because it was a bunch of me trying to get him off of me.
Commotion, I understand. Okay, so just for the record, you're pointing to your kind of like the flat surface of your wrist, correct?
Yes.
Okay, perfect. Kind of where the wrist meets the hand. Okay, thank you. And when you say that he was putting his wrist on your, you put your wrist on your neck, correct? Okay. In that moment, did you lose consciousness or anything?
I don't believe I lost consciousness. I just know I struggled to breathe and push him off.
Okay, and sorry, just to back up a little bit, when he was using his wrist, it was just one of his wrists, right?
Yes.
Not both?
Yes.
Okay. And could you feel like you could breathe in that moment?
It was struggle, it was hard. it was restricted.
Okay, so your breathing was restricted. What would you say your vision was like at that moment?
My vision was a little blurry.
Okay.
Everything was happening so fast.
Yeah, I understand that. So what was what was the defendant's demeanor like while all of this was happening?
He was very angry, very.
And was he saying anything while he was doing this?
He did, but he said violence.
And based on that, Ms. Hubbard, and everything else that you testified to today, how would you describe that you were feeling at that moment?
Afraid. I fear for my life even today.
Okay, just one moment, John. Okay, no further questions, Your Honor.
Exam.
Ms. Hubbard, you indicated that Mr. Hicks had picked you up from work, is that correct?
Yes.
And he was driving you in the vehicle back to the residence where both of you resided at that time, is that correct?
That's right.
And as he was driving back, he was expressing his concern about not being paid appropriately for services rendered for your employer, is that correct?
Yes.
And so you indicated that you did not engage, you didn't have anything to say in response, is that correct?
That's right.
And then you indicated that at some point you arrived at the residence, is that correct?
That's correct.
And Mr. Hicks went inside, but you remained in the vehicle, is that correct?
That is correct.
And at some point your daughter noticed that you were in the vehicle, so your daughter came and got in the vehicle with you?
That is correct.
And at some point you asked your daughter to go in and get your blanket or something of that nature, is that right? And so at some point you're indicating that Mr. Hicks came back out to the vehicle and was standing at the window yelling at you.
That is correct.
And he asked for your house keys.
That is correct.
But he had entered the house, right? So he had keys to enter the house, correct?
That's correct.
All right. And so your response to his request for the house keys was no, is that?
That is correct.
Okay. And so at some point he unlocked the vehicle.
That is correct.
And he got in the back seat.
That is correct.
Now, what type of vehicle is this?
Town and country van.
Okay. So this is a van, and is it fair to say that you have two individual seats in the front?
Yes.
And are there two individual seats in the back, or is it a bench seat?
It's two individual seats in the middle.
In the middle, okay. And so where was he located?
In the back seat on the driver's side.
So he's in the back seat on the driver's side, and you're in the front seat on the passenger side, is that correct? Okay. And so you indicated that at some point he takes the back of his wrist, if I remember how you wrist, the lower part of his wrist going into where his upper part of his arm is, and he reaches over from the back seat with his back side of his wrist, and he presses on your throat.
Correct.
And from the back seat, from the driver's side, he reaches over to the passenger side.
He put his body in between the two front seats.
And so he puts his hand on your throat. Is that correct?
That is correct. His wrist.
And his wrist. Thank you for correcting me. His wrist on your throat. And at some point, you struggle to breathe, but you never lose consciousness. Is that correct?
That is correct.
Now, while he's putting his wrist on your throat, at that point, is he saying anything?
He's saying that I should kill you.
Okay. And so then you indicated that at some point, somehow, you ended up with cut to or laceration to your eye. Is that correct?
Yes.
But you don't recall exactly what happened or how that occurred. Is that fair to say?
No, I'm not sure how that occurred.
Okay.
It occurred within that moment, but I'm not sure how.
Okay. And so at some point, you get this laceration to your eye, and At some point, the police are called and the police arrive. Is that fair to
That
say?
is correct.
Okay, and Mr. Hicks leaves the vehicle. Is that fair to say?
Once the police arrive, yes.
Okay, but prior to the police arriving, after you had an incident with your, his wrist on your throat, did that happen before or after the laceration to your eye?
That happened before the laceration.
Okay, so the throat was first, the laceration was second.
That is correct.
And you're confident all of that occurred as a result of Mr. Hicks?
That is correct.
No further questions.
Any redirect?
Just super briefly, Your Honor. Ms. Hubbard, I just want to ask you really quickly, did you receive any treatments for your injuries?
Yes, I went to Shuttlesworth Hospital.
Okay, and that was directly after this incident?
Yes, it was.
Okay, no further questions.
Thank you, ma'am. You may step down. Any other witnesses on behalf of the people?
No other witnesses on behalf of the people, Your Honor.
Any witnesses on behalf of the defendant?
No, Your Honor.
People?
Your Honor, at this time we reserve argument and ask to bind over as charged.
Counsel?
Your Honor, I understand that there are two counts to this charge. One is an assault with intent to do great bodily harm, less than murder or by strangulation. The other is a domestic violence aggravated second offense notice. And I would indicate that at this point, I would argue that the prosecution has not met their burden to establish that there has been an assault with intent to do great bodily harm, less than murder, nor by strangulation or a domestic violence aggravated. Ms. Hubbard's testimony was he reached from the back seat, put his wrist on her throat. It's hard to see how somebody reaching from the back seat would be able to put their wrist on somebody's throat. Their wrist only, not that his hand grabbed around her throat, not that he put any grip on her throat, but just merely his wrist was on her throat and caused her to struggle to breathe. I don't feel that the testimony rendered by Ms. Hubbard was credible, and I'd ask that case be dismissed.
People?
Yes, Your Honor. So gripping of the neck is not necessarily an element of the statutes of strangulation. But what does need to be met in the strangulation to meet those elements, just regard that someone was in fact strangled and that their breathing was somehow affected, whether it was restricted, whether they lost consciousness. And the complainant in this case did state that she, her breathing was restricted, that she did have difficulty breathing. And I think that given, certain size differences as well, it's not necessarily super shocking that someone from the back seat could apply, pressure onto somebody else. But with that being said, we don't necessarily need to prove any sort of full hand grip. We just have to prove, that someone essentially, that someone was strangled or choked and that their breathing was in some way affected by that. So with that being said, we do believe that we have met our burden.
Even more so than that, what's important here is what the defendant's alleged intent is or was at the time that he put his wrist or his hands around the complaining witness's throat. She also indicated that he said when he did that I should kill you. She said that her breathing was restricted as a result, and I didn't find anything inherently incredible about the witness's testimony. As such, the court is satisfied that people have met their burden of probable cause as it relates to the charges contained in the complaint and warrant. The court finds those charges were committed in the city of Detroit, and the court finds probable cause to believe this defendant committed them. Defendant will be bound over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information date and time will be January 2nd, 2024 at 9:00 a.m. Bond will be continued.
Thank you, Your Honor. Judges, two things I want to address before. First, I didn't hear the date of the arraignment. What date did you say, Judge?
January 2nd, 2024.
Okay. Your Honor, it is my understanding that this was Mr. Hicks' home in which this alleged offense occurred. It is my understanding that the alleged victim is no longer at the home. She has left the home. I believe when we had the PCC, she acknowledged that she had left the home. I'm asking that my client be able to return to his home at this time.
And Your Honor, yeah, Your Honor, if that's true, the people have no objection to that. However, APA Shelley Drain did just go ask the complaining witness if that is in fact true.
Okay, give us a second. We'll verify that.
Okay, and the other issue is when I was at the PCC, I asked for my client to be able to be go to work Monday through the weekend, actually 6 to 6. The court agreed to 6 to 5 Monday through Friday. That prohibits him from working on Saturdays and Sundays while he's doing his home repair work. He's asking to be able to do home repair work on the weekend as well.
Okay, Judge, we have an update. The complaining witness in this case did state that all of her belongings are in this home. So if she could just have 72 hours to just retrieve her mail and some of her belongings, then yes, we would have no objection to the defendant staying there for 50 days.
Counsel, you okay with that?
72 hours is fair for her to get her things.
Okay. Send over a proposed order to that effect. As it relates to him working on the weekends, he's doing what? Home improvement.
Yeah, he has his own business, Your Honor. I had addressed this at the probable cause conference, and you had given him 6 a.m. to 5 p.m. Monday through Friday, but sometimes he's doing home repair on the weekends as well when he's trying to finish up a job. And so he's not able to go on the weekends because you only gave him Monday through Friday.
People?
Your Honor, the people don't have any objection if he's trying to get to work.
All right. Give me an order to that effect as well.
Okay, thank you, Your Honor. I'll send it over.
All right, thank you.
If I don't see you anymore, enjoy your holidays.
Thank you. Same to you.
I'm not threatening you. Say one more word and that's 30 days. 30 days.